And what was the young gentleman that was sitting there? That he was actually really smart. I don't mind saying that, he was.
Mr. Hoffman.
Mr. Hoffman, he was really smart, and
He's coming back. You'll see.
yeah.
Don't make his head too big, Joe.
Yeah. Thank you, sir.
Thank you. Your Honor, I apologize. Mr. Parker and I had originally split this up. I have a few other things to add on this if it's acceptable. I don't intend to try to
Any
say them.
objections?
No, of course not.
Yeah, I've let everybody talk. So.
Thanks, guys.
I have just a few things to add and just some areas of the record that I think correction are warranted. First, Mr. Parker touched on the Circus case. I do think it's important to reiterate that Circus case is factually an opposite. In the Circus case, the plaintiffs couldn't identify the food that they ate that made them sick, let alone how the food became tainted with the bacteria. All they know is that they were at Circus for 3 days, eating the Circus food, and got sick with salmonella poisoning. Those aren't the facts in this case, which we have identified substantial evidence showing that real water was contaminated with hydrazine, and that our clients all were exposed to hydrazine in real water. So the question on summary judgment, as we lay out in the opposition, is whether there's evidence of sufficient exposure. And as Mr. Parker discussed, and as we lay out in the motion, there's obviously evidence that both Mr. Haley and Mr. Belsky were consuming real water at a sufficient basis for them to become sick, which is exactly what the experts testify. So at bottom, aside from anything else, this is just a question.
I look at it slightly even different than that. I mean, we have two, what was the expert's name? The doctor, was it Hudson?
Hudson, Dr.
Yeah,
Hudson's
he
not-
opined that Richard Belsky developed acute liver failure in May of 2018, secondary to real water consumption, right? And all he has to do is opine to a reasonable degree of medical probability, more likely true than not. Once he does that, unless he backs off that opinion, what do I do?
That's exactly right. It's that simple. Mr. Neale repeatedly said that with respect to Mr. Belsky's consumption, that you can anchor the time that he stopped consuming retail water and started solely consuming 5-gallon home delivery water to the delivery date, which he uses November 13th, 2017. Your Honor, that is not an uncontested fact, as Mr. Neale suggested. The November 13th, 2017 service agreement, it references 2 free bottles, and there's no evidence that delivery commenced at that time. There's no facts to support that there was any home delivery that started in November 2017. So to say that that date is an uncontested fact is simply wrong. It is contested. There's no evidence to support it. The evidence suggests, and the testimony confirms, that he started getting home delivery sometime early in the following year. And while he was getting home delivery, he was continuing to drink retail water at an amount that, at a minimum, to the extent there were bottles that he had previously purchased in his home. And I would also clarify that his testimony isn't, oh, I stopped on this date, or had any ability to say that. He said, look, to the best of my recollection, around the time I started getting home delivery, I stopped purchasing real water. I don't remember purchasing it after that. But I had them at my house and I continued to drink them, and there was an overlap, and I continued to drink retail water up until around the time I got sick. That's the testimony. He was drinking both. That testimony is confirmed by his mother, who testified that when she came to visit him, at the time he was in the hospital, he still had several unsealed bottles of retail water in his fridge. So to suggest that there's some black letter line that distinguishes between when he stopped drinking real water from retail bottles and started only from home delivery is simply wrong and unsupported by the evidence. The evidence is that he was drinking both up until the time that he became sick, and that he still had retail bottles in his fridge at that time. And Dr. Hudson, like you mentioned, his testimony is it's both. His opinion is that both contributed to his injury. So there's no, at a minimum, there are contested facts that preclude summary judgment. I want to address this frequent statement that plaintiffs were driving this train on the spreadsheet, fake Whole Foods records. To suggest that we asked for them to make up a spreadsheet, pass it around between who knows how many people in Whole Foods and who have an interest, and defense counsel, modify it before you produce it is just wrong. That is not what we asked for. We asked for the data. They produced something that they passed off as the data, and initially we did not realize that this wasn't how they maintained the Whole Foods purchase data. They passed it off as Whole Foods purchase data. We had no idea that it was a made-up spreadsheet that was modified by defense counsel before it was produced to us. We did not realize
I mean, that sounded a little bit like work product to me, but
we had no idea that.
by counsel. I mean, why is counsel modifying anything?
We didn't ask for them to make up a spreadsheet. That's not what the instructions, any directions.
Actually, I'll be candid with everyone, and there appears to be some sort of overlook here, but, and I can say this, there's not many in this courtroom, but I practiced before 16.1. I remember 16.1 in its original version. I call it 16.1.1. I remember .2, and I remember the current version. But one thing has been very consistent from the very outset of 16.1, and that's and they might have changed the language slightly, but Nevada law mandates a party is required to produce all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, and or control. That's new, probably as a result of this last edition, but nonetheless, it would say in control, under the prior versions, to support its claims or defenses.
We did not know this was a made-up spreadsheet. We relied on that. They were following those rules and producing what they were supposed to be producing.
But even,
we were wrong.
even different than that, if you're going to rely upon something as part of your defenses in a case, 16.1 mandates if it's in your possession, custody, and or control. You got to produce it, and produce it early on in the case. You don't have to wait for a Rule 34 production of documents. And that was the thought process behind 16.1 to help facilitate civil litigation without the necessity of a lot of law and motion practice and the like. I don't really think it's necessarily met its final goal in that regard. But that was the intent behind it. And I remember Commissioner Bigger talking about it all the time. And so I get that. I mean, that's been ingrained in Nevada law probably since the early 90s when 16.1 first came online. So I understand that.
And Your Honor, I think that goes directly to your ruling yesterday when you were talking about the the prejudice that came about from this. And that, I think, is important on this motion, as Mr. Neale argued, that, oh, Mr. Haley testified that he only sporadically drank the real water, and it's consistent with the purchase records that there was only one purchase in 2018. It begs pointing out that that is wrong. The testimony is up to 20 times in 2019 from Ms. Kingston. Ms. Sandstrom testified she sold it to him multiple times, saw him drinking it several times, remembered the jokes that he made about it, had conversations about it. This testimony it refutes the spreadsheets that were produced that show 0 purchases in 2019. It's entirely inconsistent. So when Mr. Neale stands up here and suggests that we have to accept this essentially work product as indisputable evidence and then argue that it warrants summary judgment in this case it's just simply wrong, Your Honor. And that is the context of these spreadsheets, where they're in direct conflict with the witness's testimony, with the plaintiff's testimony. And so when they're confronted with these spreadsheets, not realizing that they were made up and purport to be something created by interested parties who have adverse interests to the plaintiffs in this case and are contrary to the witnesses, there's confusion by it. Like you said yesterday, there's hesitation, there's second guessing. And so that's the harm from this. They want to present that testimony to you, Mr. Haley's confusion about questioning the frequency of how often he purchased and drank a particular brand of real water almost 4 years earlier. It's just totally inappropriate and wrong. And I think it just requires that sort of clarification. And next thing I want to clarify is this whole issue regarding the latency period. Mr. Neale showed you Dr. Freeman's testimony about the latency period and called it, days or weeks. And if someone drank real water the prior year and later got sick, it would be temporally impossible or implausible to tie it to real water. If it's not already clear, this argument is wildly misleading. What Dr. Freeman was saying, which is what I think any medical or epidemiological expert would say, is if you drank real water the year before and then several months later get sick with liver failure without drinking any more real water, tying the cause of the liver failure to real water is temporally implausible. But that's not what the facts are here. These plaintiffs, the evidence of their testimony of what they were drinking, the testimony of witnesses, the evidence in the case is that they were drinking real water up until and around the time they got sick. And this is consistent with the Southern Nevada Health District's case definition as part of their epidemiological investigation. One of the requirements of the case definition is that they drank real water within the 30 days, within 30 days of their illness onset. And so that is what we're talking about in latency period. It's the last time you ever drank real water, not real water that you may have drank 6 months ago when you continue to drink it daily or weekly or bi-weekly consistently up until the time that you get sick. So they're confusing the latency period with something that we don't even know exactly what the latency period is because there's no studies on it. When you're
Well, that's kind of one of the reasons why I brought up what I brought up a little earlier in the discussion. I mean, I understand latency periods and things like that, and one of the doctors opined, well, something's, just paraphrase, well, we're not sure what it is. But my point is this, unless I'm missing something, I don't know if this is a type of hydrazine. Is it a drug, is it not, is it Rockafeed, or whatever it is, the experts will testify to that. But I would anticipate, for example, when it comes to, and maybe I'm wrong, but I would have studies and journals and all those things that specifically deal with latency periods, vis-a-vis hydrazine causing liver failure, or whatever, and they just don't study it because it doesn't happen very often.
That is 100% correct, and we will have an expert on that, Dr. Cosnet, and he went out and he scoured all of the available studies. Obviously, they're not on point with blind studies saying, well, how long does it take before you're consuming something before you have these effects? But there are studies where they expose animals to hydrazine periodically, and there's some information that's derived from that. And Dr. Cosnet has synthesized that information, and he'll present it, and that's the opinion they keep putting up there, where he's saying, oh, this 21 milligrams exposure per day, and they try to pass that off as some sort of minimal threshold, when that's not what it is. What Dr. Cosnet is saying is, based on the universe of animal studies that exist and the limited information that provides, this is the range that we see. Now, it could be higher than lower or lower than that. It's not a one-to-one comparison. It happens in it's enough at these amounts, according to the animal studies, to trigger liver failure in some individuals. Now that parallels what Dr. Cosnet says, is that parallels the facts based on the hydrazine levels tested by the FDA in the concentrate. What he's saying is okay, we have the FDA testing concentrate and finding these levels, and they use the concentrate to make the water, and if you dilute it based on how much concentrate they're tending to put in the water, you're going to get a similar exposure to what is shown in several of the animal studies as sufficient to cause liver failure in some
So is there
people.
any measurement of the levels of concentrate that was specifically utilized by raw water in each batch? Was there anything like that?
The only thing that we have in that is we have the FDA testing on samples of concentrate that were stored at the real water facility after they started investigating the outbreak related to.
And how long have those concentrates been there? Do we know?
According to Blaine Jones' testimony, the last time he made the concentrate was sometime in early 2020. The samples were collected in March or April 2021, and they weren't tested until October 2021. So by the time they
So
tested
we're
them,
talking about 18 months or so, give or take?
the concentrate had been sitting for 18 months. That's the information we have on the levels of hydrazine in the concentrate that were tested. The other data point that we have on hydrazine in the real water is the Eurofins testing on the retail bottles, which were commissioned by UNFI, and that testing was done not only after, assuming that they used the early 2020 concentrate that was made to make the retail bottles that they tested in or around September 2020 through March 2021, those retail bottles that the concentrate was used to make were then tested approximately 2 years later, 18 months to 2 years later in March 2023. So with those samples, The hydrazine was produced in the concentrate in early 2020. That concentrate was used to make the samples in September 2020 through March 2021, and those retail bottles were tested in March 2023. So that's a much different, different circumstances related to the hydrazine degradation than the high pH concentrate that was made and sat for the 18 months before it was tested by the FDA. And unsurprisingly, we see much lower concentrations in the retail water than what we see in the concentrate. That brings me to the next point, which is this argument about Dr. Najm and Dr. Najm's opinion. Now, Mr. Neale on this said, well, okay, look at the retail bottle testing. We have 300 micrograms of hydrazine detected in the retail sample. Now let's look at Dr. Najm's expert report where he says up to 10 times as much. It can only be 10 times as much. So if you take 300 micrograms and then you take Dr. Najm's opinion 10 times as much, you only have 3,000 micrograms, which isn't enough to cause injury, according to Dr. Kosnick. But again, highly misleading, Your Honor, because Dr. Najm's opinion, where he says, oh, it wouldn't surprise me if it's 10 times as much, he's not talking about the urethans testing. He didn't have the urethans testing results. The urethans testing results hadn't been produced. The testing hadn't been completed. He's talking about the FDA results in the concentrate. That's what he's saying in terms of based on the circumstances of hydrazine degradation and what we know, that could have been 10 times as much. So the hydrazine concentration in the concentrate samples that were tested, which were as high as 1.77 milligrams per liter, that could have been 10 times as much. That's the range. That's what he's talking about. It could have been 2 to 10 times higher. And those numbers are off the charts. And so to suggest that Dr. Najm is saying, oh, 10 times as much on the urethans testing results is just not accurate in the slightest. Last, Your Honor, I just want to point the court to the Holcomb test, which hasn't been referenced here. And Holcomb, we cite the proper tests on page 19 of our opposition. And essentially what happened in Holcomb was the plaintiff had suffered mesothelioma. And he worked around various different, he was in the automotive industry, worked around various different automotive brake products that were manufactured by different defendants and contained asbestos. Now, in that case, the question was, well, you know, the trial court granted summary judgment to the various individual defendants who were all manufacturers of brake products containing asbestos. And so what the court did is they said, well, okay, look, when you have a toxic torque incident like this, you can't prove the exact level of the toxin that you're exposed to.
I touched upon that in my minute order.
Yes, exactly right. It's impossible. You can't know. You don't have it. You don't have the right ability to test it.
The only way you would know it if the manufacturer routinely tested for whatever that specific item might be.
Exactly. And so what the Supreme Court said is, look, we're not going to put the impossible burden on the plaintiffs to prove exactly how much of this toxin that they're alleging caused them harm was in the product. what we're gonna say is, you can't come in and say just willy-nilly, oh, well, you know, I got it from this without some sort of exposure evidence. And so what the Supreme Court said was, okay, look, you have to present some evidence of sufficient exposure. Once you have some evidence of sufficient exposure to the toxin, it's for the jury to decide. And essentially, it came down to three things in the Holcomb case. Number one, there was evidence that asbestos is capable of causing mesothelioma. Number two, there's evidence that the defendant's products contained asbestos.
Is it cited here, Holcomb, on page 19?
Yes, Your Honor, it's quoted and it's, here, I have the site if that helps. It's 128 Nevada 614.
Okay, 1 second, write down the case. And you know what I have. What's the site?
128 Nevada 614.
That is what you do. Continue on,
So
and thank you, man.
number one is evidence that asbestos is capable of causing mesothelioma. Number two, evidence that the defendant's products contained asbestos. And number three, evidence that supports an inference of probable exposure to the product made or sold by the particular defendant. Those three things equal no summary judgment. And there's been some arguments earlier about, well, it's Holcomb's a mesothelioma asbestos case, and it doesn't apply here. And while it is a mesothelioma case, and you know there's a wide range of those cases, and there's you know specific tests that were developed in that context, it's the same concept that applies here. We have.
What do you mean?
In terms of the sufficient exposure to the toxin in the product at issue. And they've applied that same sort of test. They cite in Holcomb general causation issues in toxic tort cases broadly. It's not limited to mesothelioma cases. It's just it's the same rationale that supports the holding applies in this case. And it's the same three factors. One, there's evidence that hydrazine is capable of causing liver failure. That's undisputed. Everyone agrees on it. Two, there's evidence that defendant's products contained hydrazine. That whether they disagree, or certainly it's a question of fact. There's certainly evidence, as we outlined in our motion, that real water was contaminated with hydrazine. And number three, evidence that supports an inference of probable exposure to the product made and sold by the defendants. So as we lay out in the motions, we have the plaintiff's testimony, we have the plaintiff's mother's testimony, we have delivery records, we have the cashier testimony. That is evidence of exposure to the product. Those three things equal no summary judgment. So unless the court has any other questions.
Thank you. Thank you. Okay. Thank you.
Your Honor, in rebuttal, first let me address the 16.1 issue. 16.1, Your Honor, requires a litigant to disclose under A2 either a copy or a description by category and location of all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control. We disclosed, Your Honor, on our second supplemental 16.1, the existence of the Whole Foods purchase data. We then produced the data that we intended to use in support of our defense, which is Whole Foods 00181, which was Mr. Haley's purchase data from June to August, covering the latency period for his employee. We've done that. We thereafter responded to each and every discovery request and put it on the 16.1. We've talked a lot about that. I won't.
Yeah, here's my question for you, and it's going to Holcomb. And here's my question, and it was a mesothelioma case, I get that.
Yes, sir.
And I'm looking here, and this is first line of the appeal. I guess this was authored by Justice Cherry. He's a special master for me in a number of cases. Really, and he comes in and I enjoy him. But anyway, this is the first, I guess, sentence of that. And it says, in this appeal, we examine the causation test that the courts have implemented when a plaintiff or decedent, mesothelioma, is alleged to have been exposed to a defendant's asbestos-containing products.
Yes, sir.
So my question is this, and I'm looking here, I haven't read the case in great detail, but I haven't looked at the pleadings, but was this a product liability?
Yes, sir. It's a box case.
Okay, so, and the reason why I asked that question, and I understand you said, look, Judge, you shouldn't follow Holcomb, but we're talking about the ingesting of, or an exposure to asbestos-containing products, right? It's products liability case. And here's my question. We're talking here about the ingestion or drinking hydrogen. Why shouldn't I apply the Holcomb standard to this case? I might ask the same question to the other side too, but that's why I pulled Holcomb, because I wanted to make sure that I had the parameters of Holcomb, because I'm looking here and it says, you know, they're dealing with exposure, and I would anticipate exposure probably deals specifically with inhalation of asbestos, dust, and those types of things, right? Yeah. Okay, so there's many ways to have exposure. We can agree to that, you know. It can be through the skin, it can be drinking, it can be inhaling, and all those things, right? And there's a reason why I use the term ingestion at the very beginning of this. So first and foremost, when it comes to the standard, why shouldn't I apply Holcomb?
Your Honor, Holcomb represents a relaxed causation standard from Wilson versus Circus. Holcomb has never been applied outside of the mesothelioma context. And the court shouldn't be the first to do it, because we have a very clear causation standard set out in Wilson versus Circus.
Now I get that. I understand. And I think this should be part of my ultimate decision here. This is something I have to think about. But when I come, and so I look here, and they go, this is the next line, and this is so important. And this is what Justice Cherry says, who I really respect and like. He says, quote, we take a balanced approach to find a causation test that is not overly rigorous or too relaxed, in order to assure protection for both the manufacturers, right? That's what we got here. And also, and the consumer.
Yes, sir.
It's a close one.
And so what the court does is it adopts the Lorman standard. And that's a Fourth Circuit case. And it says that requires the plaintiff to show a regular, frequent, and proximate exposure to the manufacturer's product in question. All right, and it's the regular, frequent, and proximate, Your Honor, where, according to the plaintiff's own experts, Mr. Haley and Mr. Belsky fall short. Dr. Cosnet opined, let's talk regular and frequent first. Dr. Cosnet opined that it would require 1.4 to 3.7 liters per day of real water to attain the toxicity levels.
And I don't want to cut you off. There was a claim for products liability.
Yes,
I'm
sir.
looking at it. I just want to make sure that. So anyway, but go ahead, I'm listening.
So the court, Your Honor, I'm not opposed, I think that, I think that case represents a relaxed standard. But I think even under that relaxed standard that's never been applied outside the Mesothelioma context, the plaintiffs still fall short because they don't have the frequent and proximate contact that the case requires. That's the balance that the Nevada Supreme Court said you had to strike. And according to the plaintiff's own expert testimony, that's where they fall well short. We're nowhere near 1.4 liters of retail real water a day. You don't have to look at the purchase data at all. You don't have to look anywhere except the plaintiff's own testimony.
Do I overlook the opinion of Dr. Hudson?
No, don't overlook it at all, Your Honor. Dr. Hudson illustrates the problem here. Dr. Hudson's opinion is real water caused Belsky's injury. Dr. Hudson, how can you break that out between real water, retail real water, and 5 gallon? No, it's impossible to do. I just assume it's both. That's exactly what the case we just talked about prohibits, Your Honor.
But there would be exposure to both, right?
Not regular, frequent, and proximate. That's the problem, Your Honor. The Lombard, that case still requires regular, frequent, and proximate exposure.
Now, here's my next question. Did the doctor opine that the plaintiffs, the 2 plaintiffs at issue, didn't have regular, frequent, and what was the other?
Proximate, Your Honor.
And proximate. Well, he's already given the proximate.
Well, I don't know that he has it all with regard to retail real water, Your Honor.
Okay, but see, here's my point, right? And it's kind of, you're asking me to put a jigsaw puzzle together, right? But was he directly attacked and say, look, I'm giving you all these factors. Does this change your opinion?
Your Honor, what he was directly asked was, do you have any idea how much they drank, when they drank it, what the concentrations might have been, even approximately? There was a whole list of variables that Dr. Hudson said, no, I don't know any of those things, and I'm not troubled by it because I see the fact that they're sick. That tells me all I need to know, that they exceeded the toxicity levels. That's exactly the analysis.
And was that part of his differential diagnosis? Did he do that?
I don't think he did a differential diagnosis, Your Honor. He assumed, as he says, the regularity, frequency, and proximity to give his opinion. He doesn't know any of those answers. That's the entire problem, is that under any causation standard, whether it's Wilson versus Circus, or the case in front of you right now, Your Honor, there has to be more than I drank it and I got sick. If that's exactly what Freeman said, if I find someone who's fallen, the fall killed them. Hudson says, I know what I need to know about toxicity and regularity and frequency and proximity, because the fact that he got sick tells me everything I need to know. That's an ipse dixit, it is so because I say it is so opinion that can't be tested, can't be validated or verified, isn't replicable, and is exactly what Hallmark prohibits.
But that's a different motion.
Well, it's a different motion, Your
But
Honor.
no, but it is. You're saying, look, he doesn't meet the assistance requirement under Hallmark.
Yes,
That's
Your
a
Honor.
different motion, right? We
That's-
can all agree.
That's correct, Your Honor. But what we have here, under the same set of facts, is the plaintiffs saying, in Mr. Haley's case, I bought someone at first appeared in the store, we know that's 2017. Thereafter, I bought it maybe 5 or 6 times. before I got sick in August of 2019. There's no world in which that fits into Dr. Kosnet, Dr. Najam's, Dr. Hudson's, or Dr. Friedman's opinions. That is not regular, frequent, or proximate. We know in Mr. Belsky's case, according to his own testimony, the hardest words to run away from are your own. We know Mr. Belsky said, I stopped buying retail water when I got home delivery. If Mr. Pepperman won't accept the 11/13/17 contract, we have to accept the delivery of January 2nd. That's still outside the latency period. And thereafter, I may have had a stray bottle or two from my cupboard or my refrigerator. That's not regular or frequent or proximate, Your Honor. That's why, as to retail real water and UNFI distributed real water, Mr. Haley and Mr. Belsky's own testimony dooms their claims. There's nothing to weigh against to get that against. We can't credit the plaintiffs with more than they say themselves in terms of quantity or frequency or proximity. And Sarah Sandstrom and Lori Kingston, the two co-employees, were very clear, Your Honor, when questioned. I think it might have been early 2019, but it also could have been 2018. I don't know which calendar year it was even in. That's Mr. Haley. Their best case puts it in the spring or early summer of 2019. But the witnesses couldn't corroborate that at all. They said it might have been 2018. That's a very good question. I'm not sure. There simply is nothing here, Your Honor, in terms of whether you use the Holcomb standard of regularity, frequency, and proximity, or the Wilson versus Circus standard of circumstantial evidence excluding all other alternative causes. You can't get there. The latency period and the toxicity levels prevent it, Your Honor. Those are the plaintiff's own expert opinions, and that's why UNFI is entitled to summary judgment on these claims. You'll recall, Your Honor, taking bench briefs or trial briefs from the parties on day 1 or 2 of our pretrial motions. But I think the plaintiffs, I know, and UNFW, and I think the other parties, all briefed Holcomb pretty extensively there and told the court why we didn't think it applied, but even if it did, the plaintiffs didn't meet the standard in that case. Your Honor, unless the court has questions, I'll leave the argument at that.
No, I was just looking at some of the comments from Justice Jerry in the Holcomb case. And he gets to the end of, he's dealing with it appears to me, the causation evidence. And he talked about it as far as exposure and the like. But then he finalized it with, quote, Dr. Holstein summarized his causation opinion by stating that Holcomb's mesothelioma was caused by exposure to asbestos in joint compounds and automotive friction products, period. So in that case, they had, I guess, what we could call specific causation or medical causation that was in the record.
Yes, sir, but I think it went further and it was manufacturer specific. And if I recall correctly, the Holcomb court said that the evidence was sufficient as to 3 of the manufacturers and insufficient as to 1. I forget which one. Perhaps it was Georgia Pacific. But that's the analysis that's lacking here. That's the regularity and frequency and proximity to each separate product. That
Well, we only have one product.
no, Your Honor, that's exactly wrong. We have a product that is unique to UNFW and a product that is unique to real water. And UNFW's product.
When you say a product that's unique, are you making a distinction between 5-gallon jugs?
Yes, sir.
And
UNFW has no legal liability for 5-gallon jugs.
No, I understand that. I mean, I get that. But as far, but you're saying there's a different product. I don't know if there's a different product. There's a different size of the
Okay.
products being sold.
That,
But here's my point. I mean, you can buy Coca-Cola in 32-ounce containers.
yes,
You
sir.
can buy Coca-Cola in 12-ounce cans, you can buy 16-ounce bottles.
Yes, sir.
But at the end of the day, it's Coca-Cola.
Yes, sir.
Product.
But a distributor like UNFW only has liability for what it
No, I
distributes.
get that, I understand.
And that's why we have to make a distinction between, in Mr. Wilson's case, the two products. And the quantity of one that he drank, and the regularity and proximity, versus the quantity and regularity and frequency and proximity of the other, which is entirely remote from his injuries, well below the toxicity levels his expert opines to, and outside the latency.
Concentrate changes too.
You wanna, you can, I let everybody,
That's.
I let everybody jump in the fray if you want to, that's okay. Just being fair.
Your Honor, I think under either Wilson or Holcomb, the plaintiffs fall well short because of the latency period and the toxicity period that their experts opine to, and the undisputed facts that the plaintiffs provided themselves in sworn testimony.
All right. And, any other discussion we need to have as far as Holcomb is concerned?
I don't think
Mr. Odou?
Joel DeMeth for Real Water, we don't think the court should adopt the Holcomb standard.
And tell me why, Mr. Odou. And I realize this is a little, because the reason why I bring that up, I mean, I have Holcomb right in front of me. And it appears that Holcomb involved strict products liability, that's noted in the case. I realize the Circus case was a food poisoning case.
Right.
Different animal, negligence-based concepts. Holcomb involved exposure, right? And then I indicated before, you can have exposure in many different ways. You can have exposure through the skin, you can have exposure by ingesting both in your lungs and or by drinking some, right? And we have a product here, and I'm trying to figure out why I wouldn't follow the lead of Holcomb versus food poisoning case.
We appreciate that, Your Honor. You commented upon all the things that are similar, so I'd like to comment on the one thing that is different.
Yeah, and that's why I'm giving you a chance to, you know. do
But,
something
and I don't disagree with you. You pointed out that where Holcomb is similar, I'd like to point out where Holcomb is different. At 629 of the Holcomb decision, about halfway down the page, the court notes the medical testimony presented by appellants was undisputed. We don't have that here. Mesothelioma is fairly agreed as to what causes it. Here, we have drug-induced liver injuries, and we have a wide disagreement as to what can cause drug-induced liver injuries. And the problem that we will run into if we...
I have an answer for that, though.
Well, I was going to say, the problem we run into if we adopt Holcomb is the defense has to prove to a reasonable degree of medical probability it's something else. The plaintiff just has to show exposure. And so the defense now has a higher burden of proof for an alternative cause to the drug-induced liver injury. Unless the court's going to say, hey, it's straight across the board, it's a fair playing field.
Well, here's my point, though, and when I go back to Holcomb, and it was, and I don't mind sitting down and really do a really intense review of the case, but there's a reason why I cited what Justice Cherry did at the conclusion of one of the sections, and where he was talking about the evidence. And yeah, this was under the causation evidence, and he indicated, and he talked about the different exposures. Then at the end of the day, after he talked about the exposures, he said Dr. Holston summarized his causation opinion by stating that Holcomb's mesothelioma was caused by exposure to asbestos joint compound and automotive friction products, right?
That's
And so here we have Dr.
Hudson.
Hudson, and it was an H, And he's opined to a reasonable degree of medical probability that the liver injury in this case was caused by exposure to hydrazine or real water. I mean, well, he says real water, I think. But anyway, that's what he says.
That is what he said. And I don't believe we joined this motion for summary judgment.
No, I understand.
And we're talking about what's gonna be the burden of proof at trial.
Right.
And that's where, the rubber meets the road for real water in terms of this issue.
But why can't real water offer up independent alternative causation or attack the causation theory in general? And here's kind of my point, because what I'm being asked to do, and I don't mind saying it, if I'm gonna grant a motion for summary judgment as it pertains to causation or lack thereof, I have to have a clear record, right? I can't take it and say, okay, this is what he should, the doctor didn't, because because at the end of the day, I asked one question, and that question was, did he back off his causation opinion, right? And apparently, the doctor hasn't, and that's Dr. Hudson, right? He hasn't backed up. There's probably another one here too. But when I'm looking at it through the lens of, okay, it seems to me that there's a lot of facts going on here. And as far as I can tell you this, and we haven't delved into it, but we do have the Williams case. And when it comes to causation, I'm talking about medical causation. There's a couple of things there that our Supreme Court, well, actually 3 things our Supreme Court said. They said, number 1, you can offer up an independent alternative causation theory, right? They say that. But if you do that, that has to be to a reasonable degree of medical probability. We all agree. Then they say, okay, the next level would be plausibility theory, right? And that's what they say. But they say under plausibility theory, you have to accept plaintiff's causation theory, but you have to offer up another one that's plausible. And to me, what that means is you just can't say, well, it could be this or that. No, there has to be a factual foundation for that plausibility. And under those limited circumstances, you don't have to opine to a reasonable degree of medical probability. That's what it is. Then last but not least, they say cross-examination. Well, yeah, you can cross-examine them, but I don't know. I guess maybe get them to retract their causation opinion or something like that. And that's how I see that portion of Williams. And if anyone wants to disagree with me, that's okay. Tell me what I'm missing, right?
Hearing what the court just said, I think I more agree with you than disagree with you.
Okay.
Again,
But that's what Williams says, right?
but I agree with that 100%.
Yeah.
I just don't think we need to create new laws, exciting as that may be, and adopt them as a standard for what is really a food poisoning case.
But is it a food poisoning case, right? Because remember at the very beginning of this, I brought up toxic pork concepts, right? And what was the young gentleman that was sitting there, that he was actually really smart. I don't mind saying that, he was.
Mr. Hoffman,
Mr. Hoffman, he was really smart, and
he's coming back. You'll see him again. Don't make his head too big, Joe.
yeah, I mean, I don't mind saying it, he's a young man, I was pretty impressed with him. I didn't necessarily rule his way, but that didn't mean I didn't respect his capabilities. He's very capable. And just as important too, he stayed on track. He really did, I was impressed with him. But I brought that up because I asked a specific question, specific causation. I said, who said that? He said, I did, Judge. Something like that. That's my recollection. But so when I'm looking at it from that perspective, especially involving a strict products liability case, and does Holcomb stand for the proposition that this level of causation or this analysis is limited solely to mesothelioma cases?
We think it does, or at least it's not applicable to drug-induced liver injury cases. That's the more relevant point for us, because there are too many causes of potential drug-induced liver injury. Mesothelioma is pretty specific in what it causes it from, what little I know about it. But typically it's asbestos that causes it. Here, we have multiple different causes for drug-induced liver injuries. Now, whether or not those pass the court's tests for admissibility under Hallmark, I'm not even going there yet. I'm just
No,
talking-
that's another half day.
Unfortunately so.
I'm saying that.
But I think just from a conceptual standpoint, adopting the Holcomb standard is not necessary for this case.
Well, if I could just be heard on that real fast.
Absolutely.
I don't think Holcomb applies to my client at all. It has nothing to do with, to anything having to do with exposure, because my client has nothing to do with the hydrazine and it's ending up in real water. That particular case on causation with regard to this, whether or not it's failure to warn case, has nothing to do with Hanna instruments. Thank you.
You're welcome, sir.
I would just add, Your Honor, that Holcomb doesn't relieve the plaintiffs of proving medical causation.
No, it's right, that's why I brought it up, it's right there in the case, that's right there. Dr. Hosting summarized his causation opinion by stating that Holcomb's mesothelioma was caused by exposure to asbestos and joint compound and automotive friction products, period, close quote, something like that.
So the causation is standard, is still really the same. It's a product defect case where we have to prove that the product was defective and that it was a substantial factor in causing the injury, and medical causation is part of that.
Right, absolutely.
And in terms of the product being involved, there's an exposure requirement. And really what Holcomb's saying is this is a summary judgment case. It's saying that's for the jury. If you have evidence, medical causation evidence, which we do in Dr. Hudson, and you have evidence of exposure to the product or the substance, it's for the jury to decide whether it's enough. It's just in terms of summary judgment, it demonstrates clearly that summary judgment is not appropriate given the evidence in the case. The questions of fact. On Circus, I've already stated that we don't think Circus applies because it's factually an opposite. But even if it did apply, it's still the same thing here. It's tied up in the medical causation of the evidence that these plaintiffs were exposed to hydrazine, that to a reasonable degree of medical probability, hydrazine was the cause of their liver failure. And the medical expert, Dr. Hudson, considers the potential alternative causes and excludes them. So even if you were to follow a Circus standard, that standard is equally satisfied in the case. So I don't think the court even needs to make a judgment to say one applies or doesn't apply for the purposes of denying summary judgment here, because under either case, summary judgment should not be granted.
Sir, you get the last word. I still follow protocol.
Thank you, Your Honor. Holcomb requires regularity, frequency, and proximity. The only evidence in the record of regularity, frequency, and proximity as to Mr. Haley is I bought it 5 or 6 times after the first week it was introduced in the store in 2017. That doesn't cut it, Your Honor, according to his own experts. The only evidence of regularity.
But here's my question. When it comes to issues regarding regularity and those things, were those questions put specifically to the treating physicians in this case? And were they asked, does that change your opinion on causation, right? Because, and here's my point. I kind of look for clarity of record, right? And I don't know if the record's necessarily clear, because I'd like to see if the doctor address that question.
So,
Because he does opine, standing alone, that he feels that what the causation was, and that was drinking real water.
drinking real water, sir. And he was asked, how much retail real water anybody drank or when? No.
That's not true.
Excuse me.
Oh, he didn't mean to interrupt. Go ahead.
And so all of those variables, Your Honor, which we identified as being not true, left Dr. Hudson with one possibility, which is exactly what he admitted he did. I assumed it was both. That's the opinion. That's not a causation opinion that under Holcomb or Wilson gets him over any hump. That's not a causation opinion you can submit to the jury. It doesn't even address the variables, Your Honor. That's why the court should grant summary judgment. You've been very patient. We've been over it again and again. The evidence of regularity, frequency, and proximity is lacking, period, as to Mr. Haley, Mr. Belsky, and retail real water.
here's what's important. And, when it comes to, and to be fair to everyone, I'm not gonna say at this time what standard, Mr. Odou, I'm going to adopt, but I will adopt the standard, right? We'll dig a little deep on that. But even Holcomb, if you look at Holcomb in his testimony, and this is from his deposition, he said, although Holcomb remembered using the identified joint compound product brands in Florida, Nevada, he does not recall using any particular product, or any particular job, or any particular time, and he could not identify in concrete terms how often his construction duties encompass sheet rock and drywall work, right? And so, and the reason why I think that's kind of important is this, because when it comes to rudimentary day-to-day activities and those types of things, I mean, for example, I know we buy bottled water all the time, right? And for me, it comes down to between Desante, Crystal, whatever, Geyser, and there's one more major manufacturer. I just buy whatever's on sale, right? But if you ask me which bottled water I bought last week and how much I ingested, I wouldn't necessarily know. Yeah, I drink bottled water every day. And so I'm looking at it from this perspective, and I think it's important, gentlemen, to do the best I can in one respect, and that's, you have to get ready for trial, right? You do, and I understand that, and that's very difficult. And I've looked at it, and for me, the record's not clear enough as far as whether I should grant the motion for summary judgment. I understand what the arguments are, but I would like a clearer record. And just as important too, from an appellate perspective, if I granted summary judgment, I think our Supreme Court would have questions. Judge, how can you do that when you have clear testimony based upon causation that the cause was real water? And my point is this: if you want to get into different quantities and stuff like that, you lay a foundation for that, right? But so I'm going to deny it. I'm just going to tell everyone this because I think it's important to get ready for trial. And now we're approaching 5 o'clock. And that's where we're at. And so, who's going to prepare the order?
Your Honor, Mr. Pepperman and I kind of split the duties, but since we did a joint opposition, we'll decide between the two of us and we'll get it cleared.
Okay, and you have a good record here, sir.
We do, Your Honor. We have a very lengthy record.
What time tomorrow?
I think we're scheduled for 1:15, I think. Is that correct?
1:15?
1:15.
Do we have an idea?
Wait. She needs something. Yeah, yes.
Those exhibits are not being in the record.
Oh, on the exhibits, what do you want to do with the exhibits?
Your Honor, we believe that I'm assuming you're talking about the one that Mr.
Yes.
Neale tried to introduce a proper. Again, Your Honor, I don't believe that they should be provided. I don't know if any personal identification information is there. If they're personal identifiers, they certainly shouldn't be a part of the court's records. And again, they were not attached to the motion or the reply. They may have been referred to, but not attached as an exhibit directly to the motion or reply.
We asked that the court accept them as a court exhibit and make them part of the record because they were referred to in the motion and certainly incorporated in the discovery answers by specific basis.
This is what I want to do, because at some point, they're gonna be in the record, right, on some level. But what you have to do is redact the, I think you have credit card numbers or identifiers or something.
They don't, Your Honor. They have tokens, surrogates, if you will, for those numbers.
Oh, you're saying that those aren't real?
They're masked. That's right. They have these individual shopping histories. That's the only,
There's nothing,
I don't think so, Your Honor.
I'll let them be part of the record, sir.
Thank you.
As a court exhibit or?
Of course.
So my question is what we start with tomorrow.
That's the next question. I always ask her in the
Yeah.
morning, so I'm ready, what are we doing tomorrow?
I think we're starting off with the motion, Milwaukee's motion related to Dr. Hanna.
It's number 18, Your Honor.
Yeah, number 18.
Wait.
So Milwaukee will be here in the morning.
Yeah, so tell me this, and before you go, so can you, put a check by that, and what's after that, so I can take a look at it?
What's after that, Your Honor? I have plaintiff's motion number 20.
Wait, slow down for her, because I'm gonna go to her tomorrow, sometime during the day, and say, what do I have to take a look at?
So we're skipping a bunch and going straight to Milwaukee?
No, this is plaintiff's motion limiting number 19,
Okay,
and we're doing plaintiff's motion limiting number 20.
so 19 more, or 18 more?
19 is skipping to Friday.
Okay,
And the next one is real water motion for summary judgment. Punitives. And then the one after that would be real water motion limiting number 3. And then the one after that would be real water motion limiting number 6. And we put that for its real water motion limiting number 10.
okay, so plaintiff's motion limiting number 19 is for Friday, number 18 we're hearing tomorrow?
Right.
Okay,
You got everything else here?
yes.
All right. Sir?
Nope, that's it. That's what I want. Thank you very much, Your Honor.
Thank you.